All right, let's go on the record on cause number DC 20-12084, the Canterbury Cove LLC versus the THB Construction LLC. Council, make your appearances.
Eric Calhoun on behalf of the plaintiff, Your Honor. Thank you.
Scott Hayes on behalf of the defendants.
Okay, let's go ahead and proceed.
Your Honor, by way of just brief introduction, my client is the owner, developer of a piece of property in Rowlett that they want to develop into single-family residences. And they hired the defendant, THB Construction, to do various activities, grading, paving, sewer, etc., to prepare the property to build those homes on. Entered into a contract for that purpose. Things went along for a couple years, and they were terminated. They filed a lien affidavit, and we sued them for breach of contract for failing to perform the contract. Filing a fraudulent lien affidavit with respect to the property that's holding things up there. And that's the basics of the lawsuit, Your Honor, without getting into too much detail. And here today we have a motion to compel. We had served some basic discovery back in December. Defendants responded in January. Many of the responses to the request for admission say things like they basically say they can't admit or deny, and they'll supplement. They don't explain why. They can't admit or deny that they've been done investigation or anything like that, etc. Your Honor, there's 42 responses that are like that, which, as the court knows, under Rule 198.2, if they can't admit or deny, they've got to set out in detail why they can't admit or deny, and they've got to at least admit the portions of it that they can't admit, if they can admit some of it. And they haven't done that with respect to 42 admissions, Your Honor. And then there's another 27 requests for admissions where they object that the document speaks for itself when it talks about the contract and the requirements of the contract, where they object that it calls for some kind of legal conclusion. Again, they're not detailed. They're just boilerplate objections with no explanation or discussion of it, of the terms of the request. And that's 27 requests for admissions that are laid out in our motion, Your Honor. Then we're with respect to the interrogatories.
All right, so let's just kind of do this step by step. Have you guys conferred on every one of these?
Your Honor, we sent a letter in January, which is attached as Exhibit B.
Have you spoken to Mr. Hayes?
I've tried to. I've written him letters. I've called. He's completely ignored me. He didn't respond to this motion. So I mean, I've tried to reach out on numerous occasions, and he's ignored every call and email I've sent him. So that's where
Mr. Hayes, have you?
Sure. If I can jump in, first of all, we will agree today to withdraw the objections and fully respond. I've had, quite frankly, client issues on this. I anticipated to fully respond to everything last week, and that got blown out. So I'm offering to fully respond to everything within 10 days documents, and certainly pay Mr. Calhoun some reasonable fee. And again, I think some of the objections have merit, but at this point, I think it's admit or deny on all of them. Again, there were 160 requests for admissions. Again, we've responded to all, but we'll agree that.
So you're agreeing to the entire motion to compel. Is that accurate?
Well, to the extent to fully respond, I think the only thing he has on there is that he's seeking deemed admissions on admissions where there is either an objection or unable to admit or deny. Will supplement, but we will fully respond to all the discovery within 10 days.
Response?
Your Honor, if he's going to withdraw his objections and provide substantive answers to all the interrogatories, admissions, and document requests within 10 days, I certainly would accept that. I would like the actual documents. In numerous of these document requests, they said they were going to produce documents, and nothing was provided. So I'm assuming within the 10 days also we'll get the actual documents.
Yes, correct.
And then that would be fine with me. And then if Mr. Hayes, if you could give me a call, and then we can talk about that and the case, that'd be great.
Why don't we do this? Why don't you give me a, why don't you guys send me an agreed order on this then, since this is agreed to, that details what's happened here, and go ahead and email my court coordinator, make this an agreed order, and I'll get it signed by the end of the week.
Thank you very much, Your Honor. We'll do that.
Okay, thank you.
Hey,
Anything
thank
else,
you,
guys?
Judge.
Thank you, guys. You be safe.
That's it.
Thank you.
Acevedo versus Navarro. Are both sides here?
Yes, Your Honor. Harrison, counsel for plaintiff.
Hi, Your Honor. Bill Alexander on behalf of defendant.
All right, let's go ahead and go on the record. So on the record, Tony, on cause number DC 1910397, Acevedo versus Navarro. Counsel, make your appearances.
Bill Alexander on behalf of defendant.
Harrison Wynn on behalf of plaintiff.
Let's proceed.
Plaintiff served, excuse me, Your Honor. Plaintiff served its billing affidavit stemming from a motor vehicle accident back in October to defendant. On November 5th, defendant served plaintiff 2 counter affidavits, one from a pain management physician named Dr. Prasad, and one from a chiropractor named Dr. Hare. 1801 allows
I'm very familiar with the law in 18.01. Trust
I
me.
apologize, Your Honor. Just
I
making
do
sure.
these 2 or 3 times a week, so.
Yes, Your
if not
Honor.
more.
I'll just get
So-
straight to it then. Plaintiff takes the position that Dr. Hare's counter affidavits fail to give reasonable notice, and with regard to the reasonableness of charges, just looking at the counter affidavit itself, Dr. Hare, what he deems as reasonable is only a few dollars off than what was actually charged to the plaintiff. The major difference in the totals is due to Dr. Hare failing to allow or not allowing the manual therapy treatments and the 44 therapeutic exercises that plaintiff received. He states that he will not allow such reimbursement because the charts did not meet a arbitrary documentation standard. This documentation standard he sources from these several various journals and articles that are rather outdated, one being from 2006, 2016. He doesn't state why they're authoritative, why these documentation standards don't warrant these treatments. And in fact, the only reason why he lends any reliability is because he pays for the database, which plaintiff doesn't think or believes that is insufficient to put us on notice of what he's going to be arguing. We're not sure if these amounts, that just because the charts themselves aren't detailed enough, that the treatment itself wasn't necessary. We just do not agree with that. And then with regard to Dr. Prasad, the pain management specialist, we won't argue that he's not qualified to opine on the necessity treatment. Rather, he actually doesn't even dispute necessity treatment here. He only disputes the reasonableness of charges. But I will say that his CV doesn't indicate any experience or qualifications as to billing practices for surgery centers. And plaintiff did receive pain management treatment from a surgery center. And he bases the amounts, or what a reasonable amount would be charged, from a fee database called American Society of Interventional Pain Physicians, which is basically a fee database as well. The fee database, if we were to take a look, it doesn't even differentiate between insurance pricing, Medicare pricing, whether it's localized or national. It's simply, and in fact, it doesn't even comport with what he says is reasonable. The database itself, the charges are far off from what plaintiff was charged and what Dr. Prasad deems is reasonable. So that itself is insufficient to put plaintiff on notice. And according to his own report, Dr. Prasad only reviewed one of plaintiff's providers in which plaintiff received treatment. He lists 7 other providers to which we have no knowledge of who they are, what that treatment entailed. We're not even sure if he reviewed any of plaintiff's providers. And that would go to the reliability of his opinion. And the most glaringly obvious issue here, I seem to think, is that both counter affidavits actually contradict each other. Dr. Prasad states that the 2 epidural steroid injections that plaintiff received were medically necessary and reasonable. But Dr. Hare stated that only half of the passive modalities that plaintiff received were reasonable, and that all the active treatment, the eight manual therapies and the 44 what's called therapeutic exercises were medically unnecessary. So I find a hard time reconciling the two when you have a more complex procedure like epidural steroid injection being medically necessary, and active modalities such as manual exercise or therapies and physical therapies are not necessary. And I hope that makes sense. I'm sorry, having trouble finding my words here a little bit. But I think that the two counter affidavits are defective. They are contradictory on the face, and they do not meet the requirements set forth by 1801, and it should be struck accordingly.
Response?
Sure, Your Honor. First of all, Dr. Hare, I'm not quite sure if the plaintiff is claiming that he's not qualified to give these opinions, but the last paragraph of his affidavit says he's been doing this for 21 years. He owns his own practice in Dallas. He's familiar with the billing and documentation requirements for chiropractic services, physical therapies, modalities, diagnostic imaging studies. He says he's been doing these things based on his own personal experience in negotiating care contracts with insurance companies and non-participating provider fee schedules, and dealing with patients that don't have health and care insurance and high deductible insurance. And, he's done hundreds of bill reviews for other cases in DFW area. And he uses the UCR fee schedule. So based on just that, he's got enough experience to recommend or give an opinion in this case. Then he supplements it with all these. I mean, this thing is, it's page after page after page of studies and surveys of cost and what's required and not called. Now there may be a question of fact, and plaintiff's counsel may not agree with it, but that's for the jury. We've satisfied the requirement for Dr. Hare. He's got the experience and the education under the statute, and they obviously have noticed what the issues are because they went out in detail in their motion saying, well, these are the issues and we don't agree with it. So that's Dr. Hare. And on
let's first deal with Dr. Hare.
Okay.
So let me kind of tell you, I don't know if you guys have, I give kind of the same speech for every one of these. So first off, I always strike billing clerks. So if you guys ever want to use an auditor or whatever, who's not a medical doctor or chiropractic doctor, I always strike those. So that's not an issue here. Then I require under Turner v. Peril that the counter affidavits are like to like. So chiros can counter chiros, but a chiropractor can't counter an orthopedic surgeon or vice versa. And then I go down and look at, I also, if they're relying solely on Medicare, Medicaid multipliers or workers' comp multipliers, I strike those as well. What I look at most closely is the doctor qualified? And if the doctor's qualified, are they comparing apples to apples? Have they looked at what other doctors in Dallas County charge to uninsured patients and not what they charge for contractual rates for health insurance or things like that. And so just so you know how I analyze these. So for Dr. Hare, it looks like he's countering a lumbar MRI. Is that right?
That is,
Yes, sir.
that's true, Your Honor.
So that portion is struck. And then he's also, I guess, he's also countering, it looks like chiropractic treatment. Is that right?
Yes, yes.
And he's doing that by looking at UCR. Is that correct?
He's using, well, UCR stands for usual customary fee, but yet he's also basing it on his, the fact he's been in business 21 years doing the same thing, that doing car accident cases.
Where does he say that in his affidavit? I'm looking.
Last
Let me share
paragraph of
screen.
his affidavit, Your Honor.
Let me share screen his affidavit just real quick. You said the last paragraph?
Yes, right above his signature.
The 50th percentile calculation most closely represents the
Well,
2000.
It starts out with, I have been practicing chiropractor in the Dallas area.
Oh, I see. So the last paragraph, I see. Okay. Okay, so I'm not questioning his qualifications to counter a chiropractor. In fact, I've seen Dr. Hare a number of times on these things. So he says, my recommendations on reasonable allowances are based on my professional experience, negotiated managed care contracts, which requires comparison of participating versus non-participating provider fee schedules, dealing with patients that have no health coverage, patients that have high deductible insurance plans, and have performed hundreds of bill reviews for cases within the DFW Metroplex. My UCR fee schedule recommendations are determined by comparing the 2018 fees and reimbursement survey from ChiroEco.com and the UCR fees schedule utilized by Pulse Systems to the 50th percentile calculation, the 2019 Practice Management Information Corporation, PMIC, fee directory. Okay. Yeah, that doesn't seem to do what I was saying. Okay, I'm going to strike Dr. Hare. All right, what's the next doctor?
I'm going to call him Dr. L. I have a hard time pronouncing his name.
Let me see.
Shamin, or I'm sorry, I can't do it.
That's all right. Oh, wow. I have no idea how to pronounce that.
Likewise.
Is he the ortho you said?
Yes, he is.
Right,
Well,
so
pain management doctor, actually.
Okay. So kind of let's look at his.
This is, oh, there.
Uh, so where does he get to where he doesn't agree? Let's see. Oh, wow. He doesn't do any analysis, does he?
He bases it on his experience and his of doing 100 plus of these injections a year. And he's been
Yeah, but that doesn't mean he knows what the proper charges are for an uninsured plaintiff or patient. Yeah, this one's not close. I'm going to strike this one as well. All right. Let me just make it clear, a couple things. I'm not striking them as experts. So if you want to call them as experts, I know some, the judges are doing that. This is not striking them as experts. It just means these counter affidavits are not sufficient. So you can call them live if you want to at trial, if they've been properly designated, et cetera. But I am going to strike both of these counter affidavits. Anything else, guys?
That's it. Thank you, Your Honor.
Mr.
That's it, Your
Alexander? All right, guys, you be safe, okay?
All right. Thank you, Your Honor.
Your Honor. Take care.
Thank you. Tony, let me